My name's Laura Frederick. I'm from How to Contract. This is for me the real treat to be able to help you see some of the nuances, understand why we do things a particular way, take away some of the mystery of why provisions are the way they are. So let's jump in. Before we start, the biggest disclaimer is that this is a commercial contracts NDA training. I am not a corporate lawyer. I don't do M&A, joint ventures, financings. That's not me. It's just a different kind of transaction. If I say some things that are rules, just know if you're working on corporate NDAs or employment NDAs, these rules may or may not apply to those. One of the most important things that I want to do with this training is to make sure you understand the fundamentals. I didn't learn the fundamentals when I started doing NDAs. I was tossing around words without precision and without really understanding them. And I'm a big believer if you don't understand the words, if you don't understand the terms and what exactly the law says about it, you're always going to be guessing at what to draft, what concessions to make, when to push on something, when to not, what's important and what's not, because so much of that is determined by the law. At the end of the day, contracts are an agreement by the parties that's enforceable at law, and we want to enforce all our rights. And to do that, we need to know what those are. I'm going to focus first on learning the lingo and the law. The big place where I always start are these three words. We see these a lot in our NDAs and in discussions of NDAs and confidentiality, and that's trade secret, proprietary, and confidential. Now, proprietary, the only place that we can find a meaning, a definition of it, is in the dictionary. There is no official statutory definition of proprietary that goes across commercial contracts. We just look to the plain English in the dictionary, and proprietary means something that you own or you have exclusive rights to. So, really, proprietary is an ownership concept. Confidential is the same. Confidential doesn't exist. It's not defined officially. Actually, the one footnote is there is a definition in the Freedom of Information Act in the US, which govern disclosures by government. But that's a different context. It does have a definition. But for commercial contracts, there's really no applicable definition. And when we come to this, confidential means to keep secret. Proprietary is something owned. Trade secret is in the middle of those because trade secrets are both confidential and owned. But what's different about trade secrets is it's a statutory definition. We actually do have a statutory definition that applies throughout the United States and in many cases outside the United States. And that's where we look when we want to know what trade secrets is. So whenever you have a concept that's just defined in the dictionary, it's always a little vague. Which dictionary, which meaning, but when you have a statutory definition, that provides us a lot more precision about how we use the term. We have to make sure that whatever the term is in the law, in the statute, we're in compliance with it. So before we kick into more about the details of trade secrets, let me just explain why they're so important and why you need to care. The first is because it's an intellectual property right. Trade secrets are one of the four types of intellectual property, meaning you own trade secrets. It's not this broad concept of, I own information. That's not true. With trade secrets, use them as collateral against your loan. You can identify them on your books for your valuation. They actually are an asset, an intangible asset, but an asset of the company. And I love this cartoon to share other confidential information that's not a trade secret is not an IP right. People get that confused. They think I own all this other confidential information. Not really, because you can't own something that doesn't have ownership. When we say it about things that aren't trade secrets, we're using it in this casual, imprecise way because you don't own other confidential information. You might control it, but it's not an asset. You can call it know how, but again, unless it falls into that trade secret and is an intellectual property, It's a very loose concept of owning it, but you definitely do 100% own your trade secrets. They are property right. The other reason and they're so important is because it's a powerful tool. If someone misappropriates, which is the word for infringe or steal or take inappropriately, unlawfully, if someone misappropriates your trade secret, you can take action. You can pursue them for damages, you can pursue them for an injunctive relief. All those things are possible when you have these trade secrets. Those rights may not exist to the same extent for other kinds of confidential information. But the biggest reason we care so much about trade secrets is because they're worth money. As I said, you can put them up for collateral, you can attach them to the assets. Companies that do a great job protecting their intellectual property, particularly trade secrets, can add that to the balance sheet when they are looking for investors or others. And this is another reason why it's so important for people in all roles in a company to understand trade secrets. Because when you are signing these NDAs, when handling these NDAs, you are taking action that could affect the protection of the trade secret, the very existence of a trade secret. If you don't do the NDAs right, your company could lose trade secret status for some of its portfolio of information. You can do that with contract practices, and I'll explain how you do that as something you want to avoid. Clearly, you don't want to be the one who did things that ended up causing the company to lose trade secret protection for some of its valuable information.